Friends, my name is Nizamuddin Ahmed Siddiqui and I am Assistant Professor of Law at West Bengal National University of Juridical Sciences, Kolkata. The present module entitled International Treaties versus National and Domestic Laws. The learning outcomes of the present module include: number 1, to give students an overview of different conventions, pacts, legislations, agreements and other forms of international legal instruments to enforce international law and the way it can be incorporated in national legal systems. Number 2, to acquaint students with an understanding of different ways in which international law penetrates national and domestic jurisdictions and its respective limits. Friends, let us now begin with the module. We start with international treaties and national and domestic laws. International law comprises of a system of rules and principles of universal application that govern the international relations between sovereign states and other institutional subjects of international law. In other words, international law are a set of rules that are binding between states and between nations. As per the 1969 Vienna Convention on the Law of Treaties, a treaty refers to an international agreement concluded between states in written form and governed by international law, whether it is embodied in a single instrument or in two or more related instruments, and whatever its particular designation be. The term treaty means and includes conventions, international agreements, pacts, general acts, charters, statutes, declarations as well as covenants. There are two types of treaties, bilateral and multilateral. A treaty is binding only on the parties to the agreement. The basic principle underlying the law of treaties is the principle of pacta sunt servanda, which means every treaty in force is binding upon the parties to it and must be performed by the parties in good faith. Let us now examine the difference between international law and domestic law. National law is concerned primarily with the legal rights and duties of legal persons, which includes individuals and communities within the state or similar territorial entity. National law is developed by a legal superior, mainly the parliament or person with legislative power who is considered to be legally competent by the society and in situations where the governing power has both the authority and practical competence to make and enforce that law. On the other hand, international law focuses on rules and principles that govern the international relations between sovereign states and other institutional subjects of international law such as the United Nations, the Arab League and the African Union. International law focuses on the rights and duties of the state themselves. There is no legal superior in international law. All the states have equal rights. Let us now discuss the traditional theories that are related to the subject. The relationship between national or domestic law and international law is explained through two assertive theories, the theories of monism and dualism. The first theory, monism, is the idea or it assumes that international law and national law are simply two components of a single legal system or body of knowledge and regards law as one single entity. Hence, Kelsen is regarded as the founder of this theory. Monism goes on to say that national law and international law are part of one system in which international law is at the top of pyramid, validating all the acts of national law. In case of any conflict, international law is followed as it precedes the national law. In monist models, a ratified international treaty forms part of the domestic legal order and is directly incorporated and often directly applied at the national level. Moreover, monism in practice expects the laws of nations, legal institutions to be similar to those of international law, and in case they are not, the national jurisdiction should give effect to international law and not to its own internal law. Dualism, on the other hand, was proposed by Triple and Anzilotti. This theory states that international law and national or municipal law are two separate and distinct legal systems. Due to these laws being of different systems, international law would not form part of the domestic law of the state. If any of the international laws are enforced in the state, it would be so because of the adoption by the national law of the state. Dualist models of the relationship between international law and domestic law propose that a treaty takes effect internationally after being signed by the head of state. But in order for it to have sway over legal systems, the treaty's text must be adopted through a law of parliament. National law is given priority over international law under this system. Also, in order to make international law binding on binding authorities, it needs to be transformed into national law. So, in a sense, international law and national law are two different spheres. Friends, let us now examine international law's perspective of national law. As stated in Article 27 of the Vienna Convention on the Law of Treaties, 1969, national law cannot be used to justify non-compliance of international law. This shows that international law has a higher stand with respect to national law. As held in the case of Mexico versus United States of America, the rights granted under the Vienna Convention on Consular Relations are treaty rights which the US has undertaken to comply with in relation to the individual concerned, irrespective of the due process rights under the US constitutional law. Thus, it is the general duty of the nation to bring its national law in conformity with the obligations posted under international law. It is one of the general facts that when an international rule requires the state to change a law to comply with that rule, state becomes duly bound to put in all the necessary steps to amend or repeal that law. As held by the Permanent Court of International Justice in its judgment on exchange of Greek and Turkish populations, a principle which is self-evident according to which a state which has contracted valid international obligations is bound to make in its legislation such modifications as may be necessary to ensure the fulfillment of the obligations undertaken by that state. But this conformity needs to be integrated into domestic law only when the state fails to observe some obligations on specific occasion. Friends, this is a very important issue. Let us now understand the national law's perspective of international law. Generally, national law has a duty imposed on it by international law to enact certain national obligations with the intention of implementing the international obligations. One such example in the field of human rights law is of Article 2, Clause 2 of the International Covenant on Civil and Political Rights, which states that each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. It is a common obligation placed on all the nations to ensure right to fair trial is provided in the nations. It requires setting up of a well-functioning legal system. As stated in Article 9 of the Convention on Cluster Munitions, each state party shall take all appropriate legal, administrative and other measures to implement this convention including the imposition of penal sanctions to prevent and suppress any activity prohibited to a state party under this convention, undertaken by persons or on territory under its jurisdiction or control. Moreover, international obligations are imposed in all spheres of law, be it human rights or criminal law. An example of international rule being imposed on national law is Article 88 of the International Criminal Court Statute, which states that states parties shall ensure that there are procedures available under their national law for all the forms of cooperation which are specified under this part. Part 9 of International Cooperation and Judicial Assistance is the part which the article is talking about. Now, we need to examine international courts' use of domestic law. Each international court uses different approaches to come to a conclusion. International Court of Justice being the most pronounced, states in Article 38(1)(d) that the court whose function is to decide in accordance with international law such disputes as are submitted to it shall apply judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of the rules of law. Since none of the ICJ judgments act as precedents, International Court of Justice judges rely on decisions of other international courts or decisions of national courts when an issue of international law arises. Moreover, the decision passed by the municipal courts are referred to as facts that can either use a dispute or breach of international law. As held in the case of certain German interests in Polish Upper Silesia by the Permanent Court of International Justice. From the standpoint of international law and of the court which is its organ, municipal laws are merely facts which express the will and constitute the activities of states in the same manner as do legal decisions or administrative measures. The court is certainly not called upon to interpret the Polish law as such, but there is nothing to prevent the courts giving judgment on the question whether or not in applying that law Poland is acting in conformity with its obligations towards Germany under the Geneva Convention. Thus, in conclusion, international courts cannot be substituted as appeal courts for issues pertaining to domestic law. But at the same time, international law cannot declare any national law as unconstitutional just because it is not in accordance with international law. Again, a very relevant question. Friends, let us now examine the implementation of international law in national law. To maintain peace and order, many states do try to integrate international law into their domestic system, but the problem arises due to lack of a proper implementation system. Since there is no general rule on how states should implement international law, on the one hand, it gives a state a lot of power to implement international law in the method they deem best. But on the other hand, it creates lack of uniformity with respect to the position of international law in the national legal system. Treaties are therefore written agreements which create legal obligations between states. There are various procedures to have states accede to such proposed treaties, where the text of the treaty is adopted in an international conference which calls for states to sign or ratify or negotiate the wording of the text. The treaty becomes open for signature for a period of time, for instance 12 months. States have to consent to which by virtue of it they are bound by the signed treaty. This is known as ratification or otherwise submitting the instrument of accession. The state, if disintegrated into multiple new states, may also be party to the treaties. They are known as state succession or continuation. While international humanitarian law may not be able to curb suffering and destruction that wars inherently ensue, the least the states can do by complying with such laws is that they minimize some level of suffering without which victims are bound to be abused. Protecting fundamental rights and helping to protect vulnerable peoples is the hallmark of international humanitarian law. And more states ratifying such treaties strengthen the international consensus on limit to the effects of such wars. States ratifying international humanitarian law treaties becomes essential to specifically safeguard the lives and dignity of victims of armed conflict, hence forming a juridical basis for enforcement. If a state is part of a particular treaty, then only the head of the state is competent enough to make or ratify the concerned treaty, but it needs to be discussed with the government of that state. Thus, there is no separate system used to incorporate international law in national law. Rather, national laws are such that they provide for automatic incorporation of international rules into domestic legal system. The notion of all nations consenting to the treaty in the same manner and interpretation is a rather difficult proposition. In order to ensure that the states consensually, at the very bare minimum, comply with the purpose and object of the treaty, to not undermine its substance, a reservation or an interpretative declaration may be made by a state that would not want to comply with every provision or may declare its understanding based on the interpretation of a particular provision, and that does not purport to exclude or modify the legal effect of the treaty. Cases where the states undermine the very nature of the treaty, the signatories of the treaty may object, which would want the questioning state to reconsider their position and confirm their declarations. These declarations have to be attached with the signature of ratification. Friends, let us now examine the incorporation of international human rights law into domestic legal system. For a smooth functioning of international law, it is necessary for the domestic courts to integrate the rules into their legal system. Direct effect of international law on national law allows international human rights law to rely on national courts for their implementation. However, direct effect is not the only solution. There are various restrictions which can be put up by the state. The state may adopt certain legislation in contradiction with the international rule, or it could promulgate norms restricting the possibility that an international treaty may be invoked by individuals before the national courts. Although international law does not have a huge stance in the international area, it is necessary to emerge international human rights law too. Emergence of international human rights law would give people the satisfaction of knowing that after the horrors of World War II and the wars in Europe, steps are being taken to safeguard the interests of citizens. One can say that the creation of the United Nations organization and the commitment shown towards human rights was a form of demonstration to their own constituencies that in the aftermath of World War II something could be done. Something could be done to prevent their sons from returning to the battlefield and to prevent that their countries could become Germany, the domestic law of which was unable to prevent the massacre that was done during the Second World War. Thus, the role of international law is to maintain influence on a state's politics, to ensure democracy is followed. However, all the effort put it by the international law could be set aside by a change in domestic law. A statute may abolish an incorporated treaty, or there may be a legislative declaration that a treaty does not contemplate a right to claim before courts. But it can be said that the past experience of human rights violations has strengthened the international human rights movement, which has helped in imposing certain restrictions on the domestic laws. One such case in which nations have changed their domestic law to integrate human rights law was the case of Filatiga versus Pinairala, where it was found necessary for the United States to ratify a specific human rights treaty for domestic courts to assert their jurisdiction to handle a torts case for torture and homicide committed in Paraguay by a Paraguayan national against another Paraguayan national. Let us now examine the inviolable nature of international peremptory norm, or the so called jus cogens norms and international humanitarian law. The notion of jus cogens in international law encompasses the notion of peremptory norms in international law. According to international law, there are certain overriding principles that form a corpus of jus cogens. These principles dictate that no state can derogate from by way of treaty. The object and scope of the treaty has to be in compliance with these norms in order to have any legal bearing in international law. Failure to do so will render the treaty or arrangement void. The peremptory nature of the laws restrict the freedom of states to form higher and conflicting to the higher principles of international law. While there has been some confusion on the ambiguity of such norms, consensus was finally reached as to a definition of the jus cogens in the Vienna Convention on the Law of Treaties 1969 under Article 53. While the theories of international law always accepted the wider scope of peremptory norms, it lacked a binding effect, so much so as to render treaties null and void. With such a dilemma, the International Court of Justice seemingly addressed the existence of norms in international law as a special category of international norms that require a degree of prominence. In commenting about the Genocide Convention, it said that such conventions, states do not have any interests in them on their own, but a common interest, which is accomplishment of the high purposes, which are the raison d'etre of the convention. The high ideals inspired by the convention by virtue of the common will of the common parties, the foundation and measures of its provisions. The same was discussed in the Vienna Conference, where they had appointed special rapporteurs for the acceptance of the notion of peremptory norms in international law. In short, International Law Commission formally stated and recognized the jus cogens nature of certain principles in international law, and the draft included an Article 53 on the nature of the peremptory norm, which was adopted by a majority. Article 53 henceforth formally recognized the internationally accepted definition of jus cogens. It said that the treaties which conflict with the peremptory norm of general international law, for the purposes of the present convention, a peremptory norm of general international law is recognized as a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. Not only that, the Vienna Convention also empowers to invalidate any pre-existing treaty that might be in conflict with the emergence of any new peremptory norm. At the end, let us now summarize. We have mainly learned the different legal and normative grounds on which international law is currently percolating the national legal systems of the world, either by monist or through dualist legal theories, and thereby creating a compliance mechanism for them. We have also learned that there are certain mechanisms which include ratification of treaties, peremptory norms and bill of rights by which international norms operate and function, and the limits to achieve the same targets. Friends, with this we come to an end of the module. I thank you for your patient hearing.